Alex here with part 36 of the My Docket series on child custody and visitation. I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of this series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that is because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. One other thing I could mention is, for those of you that are wondering why you're not getting all of the updates on the My Docket series, it's probably because you subscribed but you didn't click on the bell notification. If you are a subscriber, YouTube will notify you not on every single thing that I post to the channel, but their algorithm will determine which ones specifically to send you an email notification on. If you have clicked on the bell notification, however, then YouTube will notify you of everything that I put up, which will include all of the My Docket videos. We left off in part 35 with me filing a motion to have my ex ordered to turn over the medical benefits cards, dental and vision benefits cards, as well as her residential address, and finally also it requests a no contact order. The previous conflict stemmed from alternating tax years for claiming our son on our IRS tax submission, and that was resolved by stipulation, so it was relatively low stress. My mindset at the time was pretty good because I ended up getting what I wanted from the court with regards to the custodial designation. I got joint physical and joint legal custody. We had one disagreement, which was surrounding the IRS, claiming our son on our IRS tax submission, and that actually, it was a little annoying because I felt like it was a reasonable request, but it didn't go to court, it didn't turn into a hearing, so it was in the end resolved by stipulation. So I felt like I would have the same sort of outcome now. And it's still annoying because it was like the same exact thing happened. I made a request by email. I felt it was a reasonable request. I just wanted the medical benefits cards. I didn't see what the big deal was. To me, it was even more of a no-brainer, at least in comparison to my request for the to alternate years on claiming our son on our taxes. Like, I thought that was, a pretty reasonable request, but asking for the medical benefits cards, I thought that really was a no-brainer. I didn't see how I could get a no from my ex, and I did get a no. So I filed a motion, just like I did last time, filed a motion, and I thought it would get resolved by stipulation again. I just figured her attorney needed to sort of twist her arm, explain to her that what I was asking for was reasonable, but this time I didn't get a stipulation. The attorney filed an opposition, and I don't really have any regrets at this point with the approach that I had to take, because in hindsight, I would not have ended up where I ended up in 8 years if I didn't take this approach, this aggressive approach, if I just let this slide. And even with the previous motion, it was just an instinct of mine. I just felt that she said no and she meant it. She wasn't going to change her mind. The only thing that she would respond to was force, legal force. And so even though that one ended up, stipulating in the end, I don't imagine that there was any other way to deal with that problem. For sure, no other amount of negotiation would have ever made that happen. It had to be done by filing the motion. I explained in the last video, and I'll go ahead and explain it again now. When you're dealing with a high conflict ex, it's very important that you take the advice that I have outlined in the videos, delay tactics, and failing to agree. So what is going to happen in this video is very different from what happened in the video before last, which dealt with my ex's response on me asking for an alternation on the taxes, the IRS tax, claiming our son on our taxes. What happened in this video is I got an opposition. So my ex's attorney took all of the details from my ex as to why she did not want to turn over those medical benefits cards, and she did the best thing she could as an attorney. I think she probably vehemently opposed going through with my ex's wishes and filing that opposition. I think her attorney knew it would not end well, and I have a feeling that my ex just dug her heels in She probably dug her heels in the last time too, but my ex's attorney was able to sort of twist her arm into agreeing to that. But this time, my ex most likely just adamantly refused, would not take a deal, would not budge, insisted, and so my ex's attorney had no choice but to do what she was told. I mean, some people will say that an attorney always has a choice. They can withdraw, they can turn on their own client, backstab their own client, but it doesn't happen. I mean, just realistically, they don't do that. I guess some of them might withdraw, but I think they're in the minority. I mean, if you... It seems to me that if a client pushes hard enough, the attorney will just do what they're told. That's the experience that I had when it came to my ex's attorneys. She had 2 attorneys throughout the case, and they weren't really that shy about doing things that they weren't really optimistic about with regards to what they thought the outcome would be. Even if they thought they were going to lose, sometimes I have a suspicion, even if they thought they were going to get chewed out, they would still do it. So we're about to see a really good example of that in this video. I skimmed that opposition a little bit prior to going into it, and it's pretty audacious. So we're gonna go ahead now and take a look at what my ex's attorney has filed. Here we have my ex's attorney's opposition to my motion. She is resisting having to turn over those medical benefits cards, her address, and let's start with the introductory paragraph. So here she identifies herself and her client. She identifies the fact that she is representing her client, and she just briefly summarizes the purpose of this opposition, and right there it goes ahead and concedes the change of time. It's interesting. I'm going to go ahead and take a closer look at that because I'm not sure what she's talking about here with the change of time. I don't recall asking for that. It looks like maybe she meant to say that she doesn't oppose the no contact order. It's interesting. We'll go ahead and scroll down and take a look. Here we have the points and authorities. Here we have the factual background. First paragraph, she is indicating, or at least summarizing, the fact that we are each going to pay half of the premiums. That's nice. I'm not sure what the relevance is there. Scrolling down indicates that she sent me some information concerning the healthcare plan, provided a website link, and it says here that individual cards are no longer issued to dependents. That's interesting. I don't think that's actually one of the things that irritates the judge, because the judge does respond that he has never before heard of an insurance company that does not issue cards. So that's one of the things that she gets chewed out on. Let's continue though for now. She is a policy holder and her signature would be required or necessary for any care. Again, he chews her out for that. And then she cites an email that she provided me. And then she says, based on my past actions, she's reticent to give me her social security number. I don't recall asking for her social security number though. And what is she talking about with regards to my past actions? So that's not elaborated on at all. So it's just kind of a cryptic statement there, but we'll move on. Looks like we have, it says that she's been the parent to take care of him most, if not all, with regards to healthcare appointments, and that I have never taken him to any healthcare appointments, and that all of the healthcare providers already have her policy information on file, and I am not precluded from taking him to a doctor. And basically she's doing the best she can as an attorney to justify my ex's inane opposition. I mean, she can't just say, hey, we don't want to give him the cards, too bad, so sad. She has to come up with some plausible pretext for why she can't turn the cards over. And I think that given what I just took a look at, what I just read, that probably was the best that she could do as an attorney. The next line, we go into the argument here. Sorry, the next paragraph. First section indicates, let's see here. Well, she's not really She's arguing that I should have provided points and authorities and affidavits. Well, she's not really saying that I didn't do that, but she's just kind of put this blanket statement here, I guess. A little bit of boilerplate, maybe, giving the court notice as to its jurisdiction and power to enforce orders. I'm not sure what that was there for. It might be just something that she just puts into every single motion or opposition. I don't know. We'll have to take a look at some of her future filings. Next paragraph here, we have, so she's saying she complied with the court's order. This is one of the things that I told everyone about, that I told my viewers about in the video Many Fine Lines. When she is cornered, she will fall back on, well, I complied with the court's order. She won't focus on what's best for the child. She will totally ignore the fact that there are even best interest factors in play, and she will just say, well, this is what the court ordered me to do, and I complied with the court's order, so too bad. Well, that's true, but it's not going to work when the judge actually gets wind of her opposition. And I guess for now we can go through this here. She says that she's provided all the information she's required to give. She's disclosed the website. She's explained the situation with the lack of cards. She's outlined the coverage provided by the plan. And the next paragraph here, she states that even though she's the parent to take our son, to all of his healthcare appointments, Even though she has been the parent to take him to all of his healthcare appointments, I have made any healthcare appointments. Maybe she meant to say that I have not made any. I'm not sure what she's trying to say there. All of our son's healthcare providers already have her information on file, and I'm not precluded from taking him to a doctor. It seems like the same thing that she stated in the factual background. If I'm out of the area and he needs emergency care, then I can just let her know. Oh, I'm required to let her know. So she's saying if I'm out of the area and he needs emergency care, I'm required to let her know as a joint legal custodian, but apparently that's a one-way street. She's not required to let me know the same. If there's any problems with admitting him to the hospital, she could provide that information at that time. Wow. All right, let's move on to the next paragraph. Here we got another section B of the argument. It says she does not oppose the no contact order. It says we're exchanging at Denny's. It says that she would like to meet at the entryway to avoid approaching each other's vehicle. And it says that I'm asking the court to order parties to stay 100 yards away from each other's residence. In the past, I have been late for an exchange. There's no what? If there's no designee to exchange a child in order to get her son, she'd need to go to my residence with my permission. Then she would ask that be an exception. Okay, that sounds like something that she was just kind of nitpicking with her attorney. I don't recall that ever being an issue throughout the entire 8 years of our child custody dispute. Not once did she have to do that. Moving on to the next paragraph, argument section C, we have, here we have in black and white the hypocrisy. The hypocrisy with regards to the address. So she wants to know where I live at all times. And, if I don't tell her, I'm a horrible person and I shouldn't have custody of our son. However, that doesn't go both ways. Apparently, because she got a temporary protective order, now she can keep her address secret from me. Now, mind you, this temporary protective order has been expired, and she also admitted at the hearing that nothing ever happened, and the temporary protection order was really only put in place for 3 months anyway. But all of this is going to be sorted out by the judge, because what he's going to order as to this specific thing that she brings up is logical, does make sense, but leads to me filing a Supreme Court petition for writ of mandamus that pretty much kicks in the door for the entire confidential address program. I think I kind of jumped over that a little bit, but I've mentioned that in previous videos. He ends up deciding to use the confidential address program to sort of kick the can on this issue. Rather than make an order on it, he just passes it all off onto the government and sends her to the confidential address program, forces me to basically sue the government. I do eventually win, and they create a pretty gaping exception to the confidential address program. Not going to say it's an exception, but what they do is they create a way to challenge the issuance of a confidential address through the program by suing the person who claims that they are a victim of domestic violence. And all of that does end up happening, but I don't imagine that anyone who was involved in this, both my ex's attorney and the judge, thought that this would get so far out of control. at least not as far out of control as it ultimately did get, nor did they think somebody would exploit it as egregiously as she had. But this is all going to be coming out when we eventually get to that point in the series, so I'm going to go ahead and stop on that for now. We'll go ahead and move into the next paragraph. Nowhere in the court's orders in this case is there a requirement that parties provide their addresses to each other. Oh, if anyone has seen part 32 and part 8 and probably part 27, they will know that this is a dead horse that my ex continues to beat at every hearing. So this is one of the things that attorneys do. They will argue for something at one hearing and then completely change their position next time they get to another hearing. One of the things that I probably could have argued here was something known as judicial estoppel. It's also called the estoppel of inconsistent positions. So for any of my viewers, if you're going through something like this and your ex's attorney or your ex argues a certain thing, like say for example, they argued that they're entitled to know where you reside, and then later on you came back to court and tried to argue, hey, I should know where you reside too. If they try to pull this stunt where they switch positions and now try and say, hey, neither of us needs to tell each other where we live. Let's just, both of us keep each other's residence secrets from each other. If they try and pull a stunt like that, take a look at judicial estoppel, take a look at the estoppel of inconsistent positions, because you might be able to use that to block that argument from being used against you. It's basically used to do exactly what it says. If you take a position and you prevail on that position, you are stuck abiding by that position. You can't at a later date change your mind and argue, oh, never mind, everything that I said before, let's totally do the exact opposite of that. It doesn't work like that. The other thing that I wanted to say is we now have case law in Nevada. It's actually named after me, Falcone versus Secretary of State, that says in black and white from the Supreme Court themselves that both parents are entitled to know where their child resides. Even if they are the non-custodial parent, they are still entitled to know where their child resides. So you can use that case to force the court to order your ex to tell you where they reside. Unless you are actually a perpetrator of domestic violence, in which case they can use the confidential address program. The program is there for actual victims, not for people who deceive the court. I'm going to scroll a little bit further down here. Providing phone numbers to each other. Okay, I wasn't asking for that. Cell phones and email, which they utilize to communicate with each other. She's basically trying to say we don't need to know where we live because of all these other reasons. She's basically saying we can both keep our addresses secret from each other and just provide each other cell phones, email addresses, and stuff like that. She brings up the firearms, Second Amendment stuff. For those of you who are curious as to the details, you can watch part 32 of the My Docket series. All of that is addressed at the hearing, so she's just rehashing the same exact arguments she was before. At the last hearing, the court addressed... Okay, so she's actually regurgitating what occurred at that hearing. If anyone is curious as to any of these allegations, the judge handles it really well, in my opinion. Next here is, despite this, continues to carry what? This isn't true at all. It doesn't even end up going to a hearing. So I think that when we get to my reply, I deny these pieces here. And it never ends up going to a hearing. The judge just rules against her by mailing us an order. But I guess she's using this as another basis. Gonna move on down here. Scrolling into, ooh, this is a really nice little bit of icing on the cake. So your reward for asking for medical benefits cards so that you can take your child to a provider, the reward for all of that is attorney fees to punish you, because how dare you? This is something that I tell people happens. Unscrupulous attorneys have no qualms about doing this. I talk about it in the video, Defend Against Attorney Fees. If you're going to represent yourself, you have to learn how to defend against attorney fees, because one of the things that the attorneys will do is they'll try to financially break your back in order to get you to back off. It's just one of the ways that they use. It's one of the mechanisms available to attorneys to terrify you into submission, to get you to back away. And even in this situation where all you're doing is asking for the medical benefits cards, they don't pull their punches. They'll still ask for an award of attorney fees anyway. Now, the judge just denies it with a single line, a single sentence. He just says, her request for attorney fees is denied, period. That's all the effort he puts into that. But it doesn't stop them from asking, and she will continue to ask over and over again, at least 7 times, possibly 8 times, before she finally gives up. I'm going to sort of pick this apart, though. The first thing she does is that the court can make an allowance of attorney fees and costs of the prevailing party. That's a lie. No, the court can't. That's NRS 18.010. The court cannot do that. But what the court can do, I wonder if I should explain that. I'm not going to explain it because I actually cover it in a video, attorney fees and costs. Take a look at the video, attorney fees and costs, if you want more details on that. But what the court can do is use NRS 18.020. I think that's the right one. I think it might be 18.0102B. Now that I think of it, I haven't memorized it, but I'm pretty sure it's 18.0102B. That's a different statute or a subsection of the 010 statute. That specific statute allows for an award of attorney fees if they can show that you have filed a document without a reasonable basis, which is basically, there needs to be some kind of law backing up what you're asking for, or if you are filing something just because you want to harass them. So it's not enough for them to win. If they prevail, that's not enough. They also have to show that you are trying to harass them or that you've asked the court to do something without a reasonable basis. In other words, reasonable grounds or a legal basis. This was up until 2015. Now they have an additional statute that is much more wide open, but that one doesn't contemplate prevailing at all. Nothing in that statute says you have to even win. They could award attorney fees even if you lose. And if you want to learn more about that statute, take a look at the video, Attorney Fee Equalizers. I go into huge detail there as well. I'm going to go ahead and scroll down. Oh, Brunsell v. Wright. That's just an affidavit that's required. Anytime an attorney wants an award of attorney fees, they're not going to get an award unless they include the Brunsell v. Wright affidavit. It's an affidavit that contains things like that have to do with their professionalism, how much experience they have, the hourly rate they charge, how much work they've done, stuff like that. Here it says that I have continued to file motions with the court without seeking first to speak with my ex's attorney to resolve the matter. Now, this particular situation is sort of true, but kind of disingenuous. First of all, I didn't need to speak with her attorney in my eyes. I just needed to speak with my ex. Most of the time, that's what the courts want. They want you to work things out. When it comes to stuff like benefits cards, that's something that you need to talk to your ex about. If you're going to ask for, I don't know, like to modify child support, that's more appropriately sent to the attorney because that's more like a legal question. But if you're just asking, hey, can I call at this time? Hey, can we do a visit at this time? Hey, can I get the medical benefits cards? Things that don't really have to do with points of law, but just have to do with taking care of your child. That kind of stuff isn't supposed to go to the attorney. That kind of stuff is supposed to go to your ex. That's what two parents who are co-parenting do. So that's disingenuous. But even though it is true that I didn't reach out to my ex's attorney first, it is a good idea to get into the habit of doing this. Even if you give them a couple days notice, 2 or 3 days notice, it makes you look good. And this is one of the things that I do ultimately start to do in the future. I start to let her know, hey, I'm going to file this. You better do something about it. And most of the time, she doesn't do anything about it, and I file anyway. And guess what she does? Asks for attorney fees anyway. So it's one of these things that these attorneys will do is, if you are scolded for not doing a certain thing and they ask for attorney fees, and later on you comply with it and do it, they'll just find some other reason to try to ask for attorney fees. They're not going to give you any credit. They're not going to say thanks for working with me. They're just going to find another reason to ask for what they want. They kind of do this thing, it's reverse logic, where they find the conclusion that they want to reach, and then they build all of the logic behind it in a way that sort of points to that. They don't sort of put all these things together and then get to the conclusion. They do it backwards. And it's just one of the things that you have to do, get used to when it comes to dealing with attorneys. Not just like this, but pretty much most attorneys. I talk about this a little bit in the video, Win at All Costs, which goes into the average attorney's mentality, which is to win at all costs. And there's another couple of videos. I just can't remember them off the top of my head. But this is something that you do have to prepare yourself for because they can be relentless about doing this. And I think it's because it works. Even a single award of attorney fees against a person who's very poor, a $1,000 or $2,000 award against somebody who's barely making $20,000 a year, it can break that person's back. And for better or worse, with regards to what's best for the child, that parent can get terrified into submission. Next thing you know, the child is being abused into oblivion. I want to go ahead and point out the other video that kind of deals with that problem, and it's called End of Filings is Not End of Abuse. So just because a parent has stopped filing papers doesn't mean the abuse of the child has stopped. Moving on to the next section here. Conclusion. So she is asking the court to find that she has complied with the court's order regarding healthcare information and to enter an order requiring no contact between the parties and an order allowing my ex's physical address to remain confidential. Let's continue on down. affirmation, which is nice. It just lets the court know that or the clerk know that there's no social security number in this document. Certificate of mailing included in the filing itself, which is something that I highly recommend. The affidavit by my ex, which is verifying that this is backed up. Her butt's on the line if the court determines that she's lied. And it just says that all of the facts that have been alleged in this particular opposition are sworn under penalty of perjury. Here we have the motion opposition notice. Same thing. My ex's attorney checked the first box to indicate that a final decree, or a final custody order, not decree, we were never married. A final custody order was entered in this case, and the second box, which indicates that we're not trying to modify the final order. Here we have the index of exhibits. Let's take a look here really quickly. So we got the court order, looks like 2 emails, some minutes, we got another order, and some more minutes. I'm going to go ahead and scroll down. Exhibit 1. So this is the order after hearing. We've already gone over this. I think this was in part 32 of the My Docket series. Ooh, I think I was mentioning part 32 with regards to a hearing video. Okay, so for anyone that is watching, if I mentioned a hearing video as part 32, it's actually part 30. Part 30 is the video itself. Part 32 is the order that came from that hearing, from that video. So we've already gone over this in part 32 because this is actually the court order itself. And since we've already gone over this in part 32, I'm going to just skip it. But this is just the court's order that gave me joint physical and joint legal custody. Exhibit 2. We got an email here. Looks like an email she sent to her attorney. She's telling the attorney, here's the email that she sent me with the dental and vision info. She's telling me she finally finished enrolling him. Dental and vision plans. Here's the links to the plans. They're going to take the pay out of her check retroactively from the beginning of the month. Start owing January 1st, just like I do. So you owe the following for this month and every month from now on. So this seems like an old email that was probably given prior. Yeah, it's from January. So this is from prior. Exhibit 3 here. Another email. Looks like she's saying that she did supply me with the information about his insurance, that she has emails to prove that she supplied me with the information, and she's saying that she doesn't get cards for either vision or dental. But what about the medical card then? If it's true that she doesn't get cards for vision or dental, there's nothing stopping her from giving me the medical card. And she didn't give me that one either. So dentist bills it under the social security number, and she's never needed a card. This is weird. She still hasn't been able to get them to correct the cards. It just is it's like a word salad is what I'm looking at. It's like a round and round explanation as to why the cards aren't needed. They wouldn't accept my signature for the insurance. Okay, so she does actually say that in the email. Ultimately, none of this holds any water because once the court orders her to turn everything over, she complies and turns everything over. So there's this long-winded explanation about why she can't do what I'm asking. And I really want to emphasize this for my viewers. She puts all this work into, it's like an essay almost. It's like a large paragraph, 2 other paragraphs, it might even go further. Another paragraph here. And it's like all this work into not giving me these benefits cards, and then the court's order comes out, and then she turns them all over to me. So none of this was true. If for some reason I can't find the information, and then she's saying I have some rude comments. I don't know specifically what rude comments she's talking about. Oh, I'm just going to skip through this because it really is just a really, really long-winded explanation as to why I couldn't get the cards. These are the minutes. I've already gone over these minutes. These are the minutes from the TPO hearing, maybe? So I don't know why she's including this because there's a court's order. So again, we've already gone over this, so I'm going to skip over it. If any of you have any questions, I can't remember now off the top of my head what video it was, but it was probably part 9 of the My Docket series. Most likely it was part 9 of the My Docket series. I want to pause for a moment. If any of my viewers want to review this document on their own, down in the description below, you can click on the links to download this. And if you find something that you have any questions about, go ahead and post it down in the comments and I'll answer the question. But any of this stuff with regards to minute orders and court orders that I've already gone through in a previous video, I will usually just skip it over because I've already gone through and analyzed it. We got Exhibit 5. This is another court order. This one is, I already went over this one too. This one is part 31. I am mostly certain. If you want to see my analysis on this court order, that's in part 31 of the My Docket series. So I'm not going to go over this again. Skip over this. We have another exhibit here. And we have more minutes. I could have sworn this was in part 32 as well. I'm pretty sure that the court order and the minutes from that, no, it's not, it's in part 31. Okay, so I've already gone through this as well, so I'm not going to go through it again. Go ahead and take a look at part 31 of the My Docket series if you want to get my analysis on these minutes as well. Okay, so that takes care of this opposition. Going into the aftermath, I filed nothing in this particular video, so I incurred $0 in costs. My ex filed an opposition, but it was free, so she also incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney prepared a 35-page document, but about 4/5 of it was exhibits, so we're really looking at closer to maybe 5 or 6 pages of actual legal work, and it was pretty detailed. I mean, it could be more thorough, but for the most part, it seems to me like a good deal of work went into that opposition. I'm going to say 1 hour and a half, but then there's going to also be all of the exhibits having to be compiled, probably some back and forth with her client on sort of the strategy to take. So I'm going to set that at 2 hours at the rate of $250 in attorney fees. That is going to come to $500 in attorney fees for my ex. As with my previous videos, feel free to post any questions or comments down in the comments below, and I will see you guys next time.